and people who are generally persuasive, I'm intrigued by what is it they do? How do they do what they do? Because there really is an art and a science to it. And so a lot of what I'm going to cover today, and I'm just, like I said, scratching the surface.
Right.
It's unconventional and it's counterintuitive.
Right.
Because you're going to walk in the courtroom, or you've been walking in courtrooms, and maybe some of you do what I'm about to tell you to do naturally already, in which case that's really, really great. I'm here to reinforce, keep doing what you're doing.
Okay.
If that's the case.
If that's the case.
Yeah. But it's not what you would think or you would expect that you're supposed to be doing.
Okay.
So
what are those things?
Well, basically it's being natural.
Mm-hmm.
It's being spontaneous. It's being, if you can believe it, in a courtroom, improvisational. It's being emotional, and it's being authentic. It's basically being human.
Mm-hmm.
I know that's kind of unusual for a lot of people, but that's what I'm trying to say.
And we know that one of our good friends, Mitch Jackson, preaches being human for professionals as well. So
Right.
tell us how we would do that, how an expert would do that.
Okay. I'm happy to. The first thing is embrace your fear.
Okay.
Embrace it. If you're not afraid yet, then something's wrong. You should be, because the stakes are high. There's a lot on the line, even if it's only your reputation you're concerned about. And I'm assuming that's not the case with your members here. I'm assuming that they really do care about the side that they're testifying for, that they really do believe legitimately in the righteousness of their position.
Otherwise, why take that engagement?
Exactly. Right. Exactly. Okay. Exactly. So what I'm saying is, use your fear to your advantage. Like right now, I'm afraid. I am afraid.
All right.
Fortunately, there's not too much on the line right now, not compared to what I'm dealing with when I'm in a courtroom, but I'm nervous.
Sure.
And it's natural to be nervous. So I'm acknowledging that, and I want to encourage everybody to acknowledge that, because I'm going to make this point a number of times during this presentation, and that is, if you're vulnerable in a situation like that, that shows your human side, and the jury's going to want to help you, and they're going to listen better to you. And something that I've learned is that the most vulnerable person in the room is the most powerful. Mm-hmm. And so, see, that sounds counterintuitive right there, right? Because you're the expert, you're supposed to have mastery over everything. And I'm telling you, be vulnerable. Don't be afraid to show your fear if you're afraid.
And for many experts, probably most experts that I've dealt with, no, maybe not most, but at least half, have never been to a jury trial. A lot of this ends in deposition, so that they don't have. So it would be a new experience to end up in a jury trial. So there would be some fear.
Oh, I would say.
Yeah.
Yes. In fact,
and when they embrace that, would they then go that you say, use that, acknowledge it, and I think you're going to cover that again in the future. Should we then go into considering the audience and how you're going to use that? You've acknowledged that I'm a little uncomfortable being on the stand right now. Do I then consider my audience?
Absolutely. I think you should go to the next slide then.
Okay. Excellent.
You can.
So, yep, there it is. Are you seeing respect your audience?
There we go. So what you want to do is you want to put yourself in the shoes of the juror. Okay. And you're walking into a really strange situation, because in a trial, in a courtroom, it's so ironic that jurors are required, well, their jurors are performing this very basic fundamental part of our democratic process, and yet all their freedom is taken away, right?
Right.
They can't bring food or drink into the courtroom when the court is in session. They can't have their cell phones on. They can't look at them. They can't have them on. So they're cut off from communication. They can't go to the bathroom unless all of them go to the bathroom on a break. I mean, if there's an emergency, I've seen situations where people can, raise their hands, like, I gotta go.
Right.
But basically, you're sitting there and you're a prisoner of this trial. So you have to have respect for their situation. And this will automatically, I think, make you more likable, because the goal is, at the end of the day, to be likable, because that is how you're going to earn their trust and build your credibility. So you want to respect your jurors.
Okay.
Okay.
All right.
It's a very intimate setting. Once you walk in there, there's all the witnesses have been excluded. There might be some members of the public. If it's a high profile case, you might have some press in there. But what's so strange is you prepare and you prepare and you prepare, and then you walk into this room and it's showtime. And, I'm just trying to prepare people who haven't been in trial before.
Sure.
It's the court and the courtroom staff and the lawyers and the parties, depending on how many there are, and usually not that many. I mean, that could be under 10 people, and the court reporter, and then the jurors.
The trials are not generally like what we see on TV where the audience is packed as well, or it is often just the lawyers and the jury and the courtroom staff, correct?
Right. Yes. But this is an incredible opportunity for you if you're not completely taken aback by these circumstances and by the real intimate nature of this setting. So respect the fact that your jurors, this is probably their first time doing this as well. And they're not as educated as you, most likely. They want to get out of there. They want to go home. They want to go back to their lives. They want to go back to their jobs. They may not be getting paid for the time that they're spending sitting on the jury. And just respect that.
All right. Good to know.
And the reason why is because if you show respect for them, it helps build your credibility.
Okay. And then there is the credibility issue, the balancing test of the credibility.
Right.
And this, you've said this is a very delicate balance.
It is. I think so. Because on the one hand, you're the expert. So you are the authority. And on the other hand, to build trust and credibility in what you're saying, you want to be humble, you want to be authentic, you want to be human. So here are some things that you can do in order to come across as human and authentic and humble as possible.
Okay.
Okay. Number one, aside from what I said previously.
Am I on this? Do I stay on the balancing test for this?
Yeah.
Okay. All right.
And I'm just going to look at my notes here.
Okay.
Speak slowly. Give them a chance to understand what you're saying when you answer a question.
Okay.
Make eye contact with the jury, with the person you're responding to, with the judge, especially if the judge just asked you a question about an answer that had previously been given. Smile. Have I forgotten to smile today? Because sometimes I get into the material and I get intense. And, because I'm an expert about this, just like you're an expert about what you're talking about. And to be approachable and to be likable, you have to smile.
Right.
So if I forgot, just prompt me.
I will. Smile, Jennifer, smile.
When you make a mistake or you don't say something perfectly, acknowledge it. Don't be afraid to acknowledge that you're not perfect, because that immediately builds credibility and makes you more magnetic, if you will.
All right. And this
Okay?
goes with acknowledging also the same ideas. Look, I made a mistake, and it goes with acknowledging your fear. You may have made that mistake based on I'm a little uncomfortable up here.
Exactly.
Okay.
Exactly. And then the other thing I would say to do is don't speak over the other parties or the judges or the lawyers, and don't argue
All
with
right.
them. Always be polite.
This is on direct and on cross exam, correct?
Even on cross-exam, and we're going to get a little bit more into that
Okay.
as we go.
All right.
You know, Nick, I forgot to ask you, are you reserving a certain amount of time at the end for questions?
Yeah,
Because I
about
see
yeah.
we have some things coming in the chat, but I'm concentrating because they distract me a little bit. So I'm
Yeah, they're a little
and
and because we have a large audience today, I did say, we're going to try and leave 10 to 15 minutes at the end for questions. So, we're about a third of the way through. So we will do the questions at the end. We do have a large audience, so we won't be able to address all the chats.
Okay, great. So I think we can go to the next slide.
All right.
Okay. So you can sound confident by eliminating certain phrases from your speech. So you can sound confident in what you're saying without sounding arrogant. And let me also back up and say, if I haven't already mentioned it,
Okay.
use plain English as much as possible, please. About a year ago, I was with some lawyers from the Trial Lawyers College and some lawyers that weren't from the Trial Lawyers College, and we hired a communication expert to come in and work with us and coach us on our cases. And I don't do a lot of DUI cases. I'm not an expert on all of the forensic and the scientific evidence and testing that's done with these cases. But they're the way that a lot of these cases are defended often. So we had some DUI attorneys, and they were practicing their cases, and they would take turns examining an expert or examining a party and having that person give back very technical information.
Mm-hmm.
And the information was so technical that I, even with a general understanding of these principles, I couldn't understand what they were saying. And then they started speaking to themselves in this technical language, which is what I think a lot of lawyers who frequently have these technical issues, they'll do that with an expert on that topic.
Mm-hmm.
They will get into this speaking to each other in super technical terms. I couldn't understand a third of it. Seriously, that bad. And I kept asking them to explain it when they weren't putting on their cases and we had a chance. And basically, one of the things one of the lawyers was trying to get across was the idea of how you validate test results, like scientific test results. And I was playing the juror.
Okay.
Basically, what I was able to do was get them to see that if they had asked the questions in terms of, well, did you test the test to verify the results or verify that the machine was accurate or whatever it was, I don't remember, it's over a year.
Right.
Suddenly it was like, boom, breakthrough. Something as simple as, did you test the test? And so I guess what I'm trying to say is, you don't need to use big fancy words to sound like a super impressive expert.
Right.
In fact, don't, or you'll lose your jury. They won't understand you. Their eyes will glaze over.
And this is similar for lawyers, right? We always get accused of using legalese and talking in a way that people just cannot understand. So the same idea would go for the expert, that you got to talk in plain English, because otherwise with the technical language, don't they also suffer from that sounding condescending or sounding arrogant if it's too technical, or it can?
Exactly.
Yeah,
exactly. Okay. And that's not how you get people to know, like, and trust you.
Right.
And this is all an exercise in that, people, because that's how you win cases. You get people to know, like, and trust you and to relate to you on an emotional level. But now I'm getting ahead of myself.
Sure. Okay.
So, all right. So here are some tips that, oh, and by the way, Nick, my computer that had the
The slides.
slides on it just
Yeah.
crashed. So
Okay.
you're going to have to prompt me when we get to the slides, okay?
All right. I will prompt you. So you were about to hit on the phrases to avoid to build credibility without sounding arrogant.
Exactly. So, for example, drop saying before you give testimony in response to a question. Don't say, I think or I feel, because that makes it sound like you're really not sure what you're talking about.
Mm-hmm. Sounds a little hesitant.
Exactly. It's better to be it's better to say, if you're not really sure about something, I could be wrong on this. This is how it looks to me. Or I'm not completely sure about this, but don't say, I think or I feel.
Okay.
Because then you are undermining your credibility. That's a subtle thing to eliminate those two phrases from your answers.
Okay.
Okay. There's some other things that some people, like little words that people start sentences with, such as so, well, really, very. That also shows that you're being hesitant. So when you drop those from the beginning of a sentence, you sound a lot more decisive without sounding arrogant. Another word that also contributes to this phenomenon is the word actually. Because not only is that hesitant, but it's dismissive of the person that you're responding to. So some of this may be appropriate on cross-examination, but I would still say that overall, it's better and more effective to drop those words. And as far as cross goes, if you start a sentence with, like I said earlier, you sound annoyed. And you don't ever want to really sound annoyed. You don't want to sound annoyed, especially when you're being cross-examined.
Okay.
Okay.
All right.
All right. So we can go to the next slide.
Next slide is tips for building credibility.
Right. So I think I covered some of this before. Laugh at yourself.
Right.
Okay.
And smile. This would be also smiling and laughing. Okay.
Exactly. I mean, you want to be appropriate to the tone in the courtroom, to the emotional tone, given whatever it is you're talking about. So I can imagine that there are some circumstances that you would be testifying to, like a cause of death, for example, where you're not going to want to be smiling. That would be inappropriate.
Right.
Okay? But if you're talking about how much profit a business made at one point in time, you might want to smile. Like, gee, things were really, for example. And I'm sorry, I'm raising my hand because I have my phone on and I'm getting calls. So I'm just trying to decline them. Don't work to impress the jury with big words and showing how important you are.
Okay.
It doesn't work.
And I made a note on this one, because won't some of this already have been covered, the impressive part, when you qualify the expert to begin with, when the attorney qualifies the expert?
Yes.
Yeah, so you don't have to try and impress even more after that. We will have been over your CV by this point and established you as quite impressive.
Yes. And the trap that people fall into is when, and look, I understand that experts are very proud, and they should be, of their accomplishments, their education, their experience, their skill, their knowledge. I get it. But the point is, don't lead with that. I want you to lead with a more heart-centered testimony and a more human-centered testimony.
All right.
So that leads to the next slide.
And next slide. Be human, vulnerable, and authentic. Also, just we've got about 18 minutes left before questions, just as a heads up.
There's no way I'm going to finish everything. Okay, I'm going to start talking faster to try to get through more of this. I want to do my best to do that. But you may have to bring me back.
I will.
Because there's just too much, and I'm only scratching the surface on each of these topics. Okay, so perfect is boring. We don't want to be boring, okay? And that's the last thing you want to be, is boring. You want to be human, you want to be vulnerable, you want to be authentic. I think I've said this before, so we can probably go to the next slide.
Okay. Right brain versus left brain. And this is, you've mentioned you're not an expert on this, but the idea behind it is something maybe the experts want to do a little research on.
It's called cognitive neuroscience. I love that. It's just the way that comes out. But it's true. I've been studying neuroscience and the effect that that has on the way that people consume and process information.
Okay.
And so basically what you want to do when you're giving testimony or when you're a lawyer and you're presenting a case is you want to get from the left brain, which is the logical linear thinking piece of our brain, you want to pierce that and get through to the right brain, because studies have shown that it's in the right brain where decisions are made. That's where people make decisions based on emotion. And it's the right brain where all of that lives. And maybe there's some cognitive neuroscientists or brain specialists out there listening right now, in which case you can comment away and give me more information because I'm hungry for it. But it has been proven to be true that if we can appeal to the emotions, that's how juries decide the case. So the next question is, how do you do that?
All right. And that takes us to being a storyteller.
You got to be a storyteller. And storytelling has really reached a lot of popularity in mass culture these days. You hear the word storyteller a lot. If you can give responses to questions that are being asked in plain English, that adopts the emotional tone of your side, that shows compassion for your opponent, that humanizes even the other side, and if you can tell them in story terms, and we don't have time, unfortunately, in this webinar to really dig into how you tell a story, but because there's just a lot to how you tell a story, and there's a lot to how you can describe what happened, that you looked at, that you examined, that you're now being called to express an expert opinion concerning in story language. And I'm happy to come back and talk about that at another time. But just think in terms of telling the story of your side.
And you had mentioned that compassion. If you're plaintiff's expert in this situation, you can still show compassion for defense, and that would be, and that is appropriate in this case. You don't have to be hardcore against the defense. You don't have to take that hard edge against them.
Absolutely. I mean, the more compassionate you are, the more that builds trust, the more that builds credibility, the more likable you are.
All right.
Absolutely.
Should I go to the next slide? Surprising and delighting.
Okay, so this is one of my mentors. This is something that I learned from him that just made so much sense. But he's really, his name is Roy Williams from the Wizard Academy in Austin, Texas. Look him up.
Okay.
How do you get through from the left brain to the right brain? You want to surprise and you want to delight. And you don't want to be afraid to be creative in how you deliver information or explain a situation. So you want to be interesting. You don't want to be boring. If you can use an unusual anecdote, go ahead, use it.
And you've said to me that you have experienced one expert in your 30 years of trial experience who has done this, and that was in like business appraisal and valuation type of thing. So it's not that it's that's not the most interesting of areas necessarily. It may be considered more dry to the jury, but you've seen it successfully done by one expert in your experience, and this is somebody that you've used multiple times,
because he just has a way of taking a complex idea and explaining it in a way that's unusual but makes sense and is appropriate to the situation. So I guess what I'm trying to encourage experts to do is be more creative and spontaneous to the way that they approach giving technical information. So it's
Okay.
less dry, so that it's not just how you are, how you show up when you're giving that information, it's what you say. So it's all of these things that are going to help you be more persuasive and more magnetic.
Okay. All right.
Okay. You want to go to the next slide?
I am preparing like an actor for the role.
Yes. Okay. So prepare like an actor for the role.
Now, this is really counterintuitive, I think, for
It's
many.
counterintuitive. I think that some experts that I've worked with over the years, and I just said, I think that, you shouldn't say that. I caught myself, see?
Right.
Some experts do this naturally and others don't, but
Mhm.
it's something that we all can do if you practice.
Okay.
And basically, emotional tone. You want to consider the emotional tone of the case and of the reason that you are being called to testify, and set that scene in your own mind before you step onto the witness stand, step into the courtroom and climb onto the witness stand and sit down and start to talk.
Mm-hmm.
It's really important that you bring something personal to the process. And what you bring that's personal to the process is, and I have studied acting, so I know, these actors prepare by grounding the situation or the scene that they're about to perform in something personal in themselves. And I invite the audience, the listeners, the watchers right now to do the same the next time that they testify, because that will help you be more human. It'll help get you in touch with that emotional part of yourself that we really do want to have come through when you're testifying.
Yes, I like that. And so that would be thinking about your party and the other party and what they're experiencing. Would that be one of the ways to increase your range of emotions while you're discussing your particular test and your test results?
Absolutely. People are in a courtroom because there's been a total breakdown in the human relationship. And I don't think it makes a difference if the dispute is between a corporation and an individual or two corporations, because corporations are basically organizations of people.
Mm-hmm.
And somewhere along the line, something happened involving people to cause some kind of a breakdown, some kind of a conflict, some kind of a controversy.
Mm-hmm.
And the talented lawyers are able to depict that, because that is what's going to move the jurors to make a decision for their side. And you, as the expert, have the same job. You need to describe the situation compassionately in a non-scientific way as much as possible. Don't sound like a scientist. Sound like a human.
And this is, and then you say in this slide, remember the jurors are primarily interested in you. They're basically primarily interested in whomever is on the stand, correct? And at this point, that's who they're interested in.
Yes. Okay. So I'm going to where I got that from. I have to give credit to a controversial person who just passed, Roger Ailes. I'm sure you're all familiar with who he is. He had a lot to do with coaching Ronald Reagan into becoming the communicator that he was. And Ronald Reagan, our former president, is known as being
the great communicator. Right.
Okay. Well, Roger Ailes had a lot to do with that. And he also created Fox News. And we're not going to make this political, I swear, I promise. But I have to, and I do respect Roger Ailes' contribution to this topic. And I'm going to read a direct quote from his book, You Are the Message, which is, to be a really good communicator, start by knowing how you feel personally about what's going on. Then, once you are aware of your own emotions, you can more easily communicate the right tone to others. And he's also an advocate of you have to bring something personal, something of yourself to the communication process if you want to magnetize and persuade.
All right.
Okay. Because, as he also said, first and foremost, the audience is primarily interested in you.
The communicator,
the person.
right.
Okay.
All right.
All right. So I would go one step beyond that, and that is to also say that, like, and it relates to the last slide, the preparing an act like an actor for the role.
Mm-hmm.
If you can start with you and how you feel about what it is you're about to say in this case, and the importance of the testimony that you're about to give and how you're going to serve these parties and help justice.
Mm-hmm.
If you can root that, have that be the foundation of what it is you're about to say, explain in plain English to the jurors with all sincerity and feeling a sense of emotion in that story, you're going to be a killer.
Excellent. And how are they going to prepare for, and you have some things that, should I go to the next slide?
Yes.
I guess is what I'm asking.
Now it's
I
time.
guess that's what I'm bumbling over.
Yeah. You want to be spontaneous and improvisational because that increases your ability to persuade.
Okay.
It makes you more likable. And remember, when you're likable, you are more likely to persuade with what you're saying. So look at your testimony as being a pitch to the jury. And so you want to pitch what you're trying to say without sounding salesy, as you said in the introduction. So
Yep. You have 4 tips for this?
I do.
Okay.
I have 4 tips.
We got about 6 minutes left.
See, I'm not going to finish everything, but okay. I hate to rush because I feel the content's really important. I'm going to do the best I can.
Okay.
It's really difficult in this setting where there are a lot of rules and formalities that you have to observe. It's really hard to imagine that there's much opportunity to be improvisational. But I promise you that if you start looking into improvisational techniques and tips and tools and strategies, and I'm going to cover some of these now, that if you adopt those and you practice those while you're in the courtroom testifying, it will change the way you answer questions. Okay?
Okay.
So, number 1, listen carefully to the question that they're asking. That's number 1. Listen, listen. Okay? Be prepared. Number 2, in response to the question, when you're listening, react naturally and in the moment. Like you're hearing the question for the first time. Of course, you haven't heard this question. You're expecting them because hopefully you've prepared the attorney and practiced this a little bit. So you want to react naturally. Be alert. Well, this is number 4.
Okay.
Be alert, aware, and flexible and in the moment as if you are co-creating a scene.
Okay. This goes back to being an actor.
Exactly.
Okay.
You want to be able to work without a script. You want to be fluent with your information. You want to be able to adjust to the nuances of the moment. And believe me, there will be nuances. There might be a question that gets an objection that's sustained by the judge. And then there might be a rephrasing of that question. And you have to listen super carefully in order to give an answer that's going to respond to that question in a way that's persuasive. So it requires that you be fluent, and that requires that you be prepared, and that you be natural, and that you listen.
Okay. Excellent.
Okay? So be ready to expect the unexpected, right? Because trials, they never go exactly the way you think they're going to go.
Right.
They never do. That's litigation. Nothing prepares you for the actual fight in the street. I don't care if you study martial arts or whatever. You get outside and suddenly it's a different ball game, if you will.
Excellent. And was there one ninja tip? Did we cover the ninja tip? I missed that.
Let's see. Where's my ninja tip?
I think that was in case I think this was depending on the experience of the attorney. They may stick rigidly to a script, and how do you adapt to that?
Right. If that's the case, then it's even more important that you be prepared thoroughly so that the story of the client resonates with you and comes through what it is you're saying, because that is how the jury is going to identify with you. And we want the jury to emotionally identify with you, to
Okay.
emotionally resonate with you,
All
because
right.
that's how they're going to decide the case.
Excellent.
Yeah.
And do you have a uh, few items here, the kind of last tips and tricks before we run over to our, you had some more tips and tricks, the don't be contentious, show empathy and
Right.
compassion items. Maybe we'll just run through those before we start
Yeah.
taking questions.
Yeah. Let's do that.
Okay.
Okay. So don't argue. Don't be nasty. Don't get into it with the other attorney. Pardon me. Show empathy. I can't stress that enough. When you're being cross examined, especially if you're testifying for the defense, for example, in a PI case where someone was injured badly, usually, or they wouldn't be in that courtroom, you still want to show compassion for the injury, compassion for the situation. You don't want to be dismissive and arrogant. Show compassion to be more likable. Okay.
Okay.
Um, be comfortable with yourself. And I think that the others I've covered amply already.
Okay. And being comfortable with yourself oftentimes is just, it is in large part being prepared, correct?
Absolutely. It's being prepared. It's being
So
prepared.
I'm going to
One more
leave
thing.
this. Yeah,
One
go
more thing.
ahead.
One more thing. Roger Ailes, You Are the Message. It's an incredible book which really talks about how to become a great communicator. And it really does begin with you. And that's a Jerry Spence quote, who's one of the most esteemed trial lawyers in the history of this country. And he says, it all begins with you. It all begins with you. And I really think that if we can just be grounded in ourselves and know that we're good and that we're fighting for justice and that we're prepared and we've done a good job and we care about the outcome and we want to serve, then when you stumble and you fumble, just come back to yourself and you'll be fine.
Excellent. Excellent. So let's jump into some questions in the last 10 minutes. Are you ready for a few questions? I'll read them
Yeah,
from, we
let's do
got
it.
4 questions here.
Okay.
First one comes from Patty, and Patty asks a kind of a two-part question. What's the best response to an attorney asking, in quotations, generally speaking, what do you think about? So it's sort of that open-ended, generally speaking. How does she respond to that?
You mean, let me make sure I understand the question because I'm not reading it because I got
Sure.
kicked off.
That's okay.
My laptop kicked me off. Okay, so is Patty saying that how do you respond when someone asks you an open-ended question?
Yeah, in fact, it sounds like somebody said, generally speaking, what do you think about da 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 da? So generally speaking, they're asking for a generally speaking. She's been told that an attorney court does that. I have been told that an attorney in a court of law does not have to tell the truth. It is up to me or my attorney to point this out during what appears to be an untruthful summary or misleading question directed at me. So I think she's looking for some guidance. If the attorney is being very open-ended, generally speaking, what do you think about such and such?
I would say answer the question truthfully and tell them what you generally think in terms that are favorable to your case because that's your job. I
Okay.
would think, first of all, that question I'd object. Most likely, I would object if I was the lawyer for your side, if the other lawyer was asking that question. If your lawyer is asking you, the lawyer for your side who hired you is asking you that question, then you should have rehearsed and have an idea ahead of time going into the trial exactly what kind of information they're trying to elicit with that question. But
Okay.
if you are in the moment and you're listening carefully and you're well prepared and you know what you have to cover, and if someone asks you an open-ended, like if I ask somebody, which I rarely do, an open-ended question like, generally speaking, I'm asking you to give some crucial information that basically summarizes our position.
Okay. All
I
right.
hope that helps.
I think that's good. So Ricardo asks, what to do if you contradict a trivial statement you made in deposition, but on which the opposing counsel fixates?
Explain it.
Yeah,
Maybe I misspoke, or let me clarify that for you. These are the kinds of ways that I think are totally acceptable on cross-examination in a trial. When they go to impeach, try to explain it. Yes, I said that, and what I meant was, without being argumentative.
okay. All right.
I hope that helps.
Another one from Ricardo. How can one use to their advantage the fact that opposing expert may have a greater reputations and may have greater reputation and credentials?
Well, let's just hope that that person is super arrogant and so full of himself or herself that they don't prepare or work as hard as you do, and they don't have as much heart as you do. And Jerry Spence, who is a mentor of mine, says that he's terrified to go up against a person who's younger and less experienced, but who has all the conviction and all of the emotional stuff to support the reason why they are there. So if you have that burning passion for your cause, jury's going to feel it. That's going to influence the outcome.
Excellent. So that is the prior preparation prevents poor performance.
Yeah.
Yeah. Yeah. Okay.
Yeah, that's part of it. And then also just, bring your emotions with you.
Right.
Don't leave them outside. Bring them in the courtroom.
Right. And Rebecca asks, in the world of video depositions that may be used in court, how do we get the opportunity to tell a story of how or why we think something had happened or caused a problem?
Well, you may not, but it would help before you take your deposition if you were to learn some storytelling skills. That would help. So that way, when you're in your deposition, you can have those in mind when you're answering the questions or when you're preparing to give the testimony for the deposition.
Excellent.
And storytelling is an art, people, and there's a lot to it. And there's a lot of different ways to tell a story, a lot.
And there are a lot of resources out there that they can reach out to and find. And I'm going to put up your slide again here. Jennifer's one of those to help with storytelling. You can reach out to Jennifer. By the way, we have about 5 minutes left. If anybody has any more questions, please feel free to put those in the Q&A section. Sorry if we did not get to your questions if you made questions in the chat. We did not have an opportunity to review those. But Jennifer can be reached at law@jgardnerassociates.com. They can also email you at romehowell@gmail.com. And your phone number is available on the screen there. You can find her at jgardnerassociates.com or romehowell.com. She's also visible on Facebook at Jennifer B. Gardner and also on LinkedIn. Let me see if another question came in. Any other questions before? We've got about 50 some odd people in the audience, so please ask your questions. We got about 4 more minutes. I'm going to go over to the chat now that, let's see, we do have a new question. Michael asks, could you talk a little bit about communicating with your lawyer from the stand? Oh, that's a good one. How do they communicate? Is it all eye contact?
Well, that's, Michael, if you're still there, can you clarify a little bit more about what exactly you want to know? Because, and also, have you ever testified? Have you qualified and testified in a trial before? Because indicating and communicating witness to lawyer is very frowned upon. Mm-hmm. But let me tell you, I was in trial last week and I asked a question and my client gave the worst possible answer. And then there was an objection. And then the judge was thinking and dealing with the other party. And I didn't communicate with my client, but he has worked with me long enough to know well enough that I was not happy. So there's body language,
Right.
but don't indicate. You can't do that.
Yes.
You cannot do that. No smoke signals, no hand signals, no. You can't confer.
Right.
You're really at a disadvantage when you're the expert.
Okay.
So I would say prepare in advance and listen.
Yeah, he said he has testified. Sometimes he may want to let the lawyer know that there is a need to expand on cross-examination question, for example, and you're saying, sorry, you can't let that happen, essentially.
Well, you can come back and say, I want to, if you want to go rogue,
right.
Can I just add to an answer that I gave a moment ago? Because I just thought about it and I realized that I didn't say everything that I need to say to really answer that question. You can try that. Be assertive, especially if it's important.
Okay.
Be assertive.
And Tracy asks, what are good ways to address questions on evidence where there is a possibility that something happened, like the wrong medication was dispensed, but it is not a certainty?
Well, I mean, you're being asked to give an opinion where you're being asked to assume certain facts, right?
Mm-hmm.
So ask me the question again.
Yeah. So Tracy, and you may need to elaborate on this, Tracy. What are good ways to address questions on evidence where there is a possibility that something happened, but it is not a certainty that happened?
I think you have to phrase your answer as assuming that this is true. I mean, that's basically, you're basing your entire opinion on this assumption. It's kind of, this question to me is kind of an incomplete hypothetical itself. So it's a little hard to answer. If you want to contact me outside of the webinar, I'm happy to, that applies to anybody who's asked a question. If somebody wants to contact me, I'd love to get into these questions with you deeper. Yeah.
And Jen you do one-on-one coaching. Is that right, Jen?
I do. Yes.
Okay, so you may want to reach out to her. We don't have time for any more questions right now. I am actually going to stop sharing the screen, come back here. We don't have, sorry if we didn't get to all the questions. Again, we had a huge audience today. Probably ask Jen to come back in the future to cover some more things because we realized that it was a lot of information taken in a very short time. But please reach out to Jen directly if you have any questions. And we will be uploading this to YouTube later this week and hope that you can run back and see that. Jen's email, I am going to post it here in the, which one do you prefer? Do you prefer the?
Either one. I check them regularly.
Gmail.com. So romehowell@gmail.com, and we will have this information also up on YouTube shortly, and by the end of the week, I'm going to say. Everybody, thank you for being here. Jen, thank you for taking the time with us today. And any last comments you want to make before I hit stop recording on this?
I just want to say thank you so much for the opportunity to talk to your audience. I really appreciate it, and I had a good time. So thank you.
Thank you, everybody. I appreciate it. Have a great day.